We are on the final day of the state legislative session. It is known as Sine Die. It is a day where a lot of political news is made and a lot of attention is put on the state's code book, the laws that are on the books, and sometimes the changes some people want to see to those laws. One group that wants to see some changes is the Center for Reproductive Rights. They have filed a lawsuit this morning on behalf of several Georgia midwives. They're challenging state laws that they say make it difficult for midwives to work in Georgia. Hillary Schellner is senior counsel for the Center of Reproductive Rights and is also the lead attorney in this case, and she joins us now. Actually, let's hang on now. We're going to play a soundbite from a press conference with Hillary Schellner from earlier this morning, and then we're going to hear directly from Hillary on the back end of this. But let's set it up with this. This was Hillary Schellner earlier today announcing this lawsuit.
Georgia's laws don't just limit care, they treat midwives like criminals. State law bans many trained midwives from practicing altogether and threatens them with jail time if they do. And those that are allowed to practice are often forced into unnecessary, expensive contracts with physicians just to do the job they were trained to do. The result is fewer providers, fewer choices, and a broken maternal health system that is failing too many families. It is no coincidence that Georgia has among the worst outcomes for maternal and infant health in the country. The laws leave pregnant people with too few maternal health providers and few real options for care outside of hospitals. And the situation is getting worse.
Morning, and Hillary is now joining us live. Hillary, thanks for being here. We appreciate it.
Thanks for having me.
All right, so let's start here. For people who maybe are not intimately familiar with Georgia's statute book, under current Georgia law, what can and what cannot midwives legally do in our state right now?
So some midwives are prohibited from practicing altogether. Those midwives are experts in home and birth center births, so the state has completely cut them out and threatens them with jail time if they practice. And nurse midwives technically are allowed to practice, but they must do so in a contract with a physician, which often costs hundreds or $1,000 a month and is not only prohibitively expensive, but unnecessary because nurse midwives are highly trained, independent providers.
And if I'm sort of synopsizing both what you've just laid out there and what your suit alleges, it seems that the core argument does come down to those two sort of buckets of argument. There are, under current Georgia law, midwives must have a nursing degree to practice, and if they're practicing, they've got to have a formal written agreement with physicians that describe when physicians must intervene in evaluating or treating patients. Is that correct?
Well, not only when physicians must intervene, but really that agreement describes the scope of the nurse midwife's practice completely. So it leaves to physicians to determine whether nurse midwives can practice and on what terms. And that just makes no sense, especially in a state where there are severe maternity care provider shortages, right? There aren't even enough obstetricians to serve Georgia families, and now they have to also work alongside nurse midwives in a way that is unnecessary.
And I'm glad you teed it up because I wanted to ask you both about the public policy argument component of this conversation and also the legal argument component of this conversation. I think you referenced the public policy argument. Let's talk about the legal component here. What would you say to folks who might make the argument that states have reasonably broad powers to regulate how industries within their borders conduct business as a way to push back against the claims that you're making here?
So I think we know Georgia's laws are among the strictest laws about midwives in the entire country. Nearly every state around Georgia allows midwives to practice more freely than Georgia does. So there is no reason why Georgia has to remain this outlier. again, especially against this backdrop of a maternal health crisis. The system we have now is not working, and we know from other states and from other countries worldwide that midwifery is a part of the solution out of that crisis.
What specific changes would you like to see to Georgia's statute? If you get everything you want out of this suit, everybody else who's involved, your clients, the plaintiffs, what would Georgia code, what kind of regulations would those code books have on the books that would be different from the current state of play?
So we are asking to restore a legal path for midwives to practice, right? Midwives have been the backbone of maternity care worldwide for generations, and Georgia and other states in this country systematically push them out. So we are asking for midwives to be able to practice without the threat of criminal penalties hanging over them, and to be able to practice as the autonomous, highly trained providers that they are, who absolutely collaborate with physicians and other providers when necessary, but that is not a constraint on their practice and a constraint on their ability to serve Georgia families who want and need the care that they provide.
Let me ask you two last questions here before we let you go. We're short on time, but I know this is a conversation that a lot of people are going to be very interested in. I want to ask you this first. I am sure that there are going to be some people who hear this suit has been filed, and they're going to be glad that it has been filed. I suspect there may be some others, including maybe some lawmakers under the Gold Dome, who may hear that this suit has been filed, hear the challenges being made, and they may push back and make the claim that giving birth is a serious medical event. It can carry unexpected complications that can emerge really quickly, and giving birth in a situation or a setting that's outside of a hospital or outside of a doctor's care, they may argue could raise the risk of hazard to the mother or to the infant. To somebody who would raise that point, what would you say to them?
I'd say these laws are not about safety. They actually make pregnancy and birth less safe by denying people access to providers. Right? People right now are foregoing prenatal care. We know in Georgia, 80% of maternal deaths are preventable, and most of them happen postpartum, which is a time when midwives can come in and check more frequently on patients who have given birth and on the baby. So, I think that is something that's often raised, but the current system we have now, which is excluding midwives, is not safe, right? And we need to do something else.
And so I want to end by asking you sort of the opposite end of that question I just put your way. For your plaintiffs who are midwives and for their clients, the expecting mothers who they work with, what do they say has been the impact of being able to work with midwives when Georgia's statute permits it?
So we know that pregnancies that are cared for by midwives have fewer interventions. People are more often likely to breastfeed. They report more joyful and positive pregnancy experiences. This is a significant personal life event that should be happening the way people want it, right? Among extended family, if that's what people want. So it is a positive experience of welcoming new life into the world. So that's the experience our clients have with the families that they are able to serve out of state, and they would like to be able to provide that same care to Georgia families.
All right, Hillary Schellner, Senior Counsel, the Center for Reproductive Rights, joining us now after filing a big lawsuit just a few hours ago. Hillary, thank you for your time. We appreciate it.
Thank you.